welcome to the Bridgewater Township Planning Board regular meeting for
Need a microphone.
September 5th, 2023. Adequate notice of this meeting has been given in accordance with the Open Public Meetings Act, NJSA 10:4-6. Proper notice was sent to the official newspapers of record, filed with the clerk of the Township of Bridgewater, and posted on the municipal bulletin board in the municipal building and municipal website on January 13, 2023. Please be aware of the Planning Board policy for public hearings. No new applications will be heard after 9:30 p.m., and no new testimony will be taken after 10 o'clock p.m. Hearing assistance is available upon request. Accommodations will be made for individuals with a disability pursuant to the Americans with Disabilities Act, or ADA, provided the individual with the disability provides 48 hours advance notice to the Planning Department before the public meeting. However, if the individual should require equipment or services, such as a cart transcriber, 7 days advance notice, excluding weekends and holidays, may be necessary. I ask that everyone please rise to salute the flag. Ms. Probst, welcome back. Could I have a roll call, please? Here.
Good evening, here. Here.
Here. Here.
Here.
Thank you, Ms. Probst. At this time, I'd like to open up the meeting to any members of the public who wish to address the board on any other matters not listed on the agenda this evening. Seeing none, moving on. We do have some minutes to approve this evening, and I believe they are from August 15th, 2022.
Motion to approve.
That's Councilman Ring.
A second.
That's Ms. Sikora. Could I have a roll call, please? Yes.
Yes. Yes.
Yes.
Oh,
Just to clarify, this year minutes are from a year ago, August of 2020?
no.
Or is that a typo?
Oh, we need to fix that.
Read the content, but the very top line. So, modify that motion to approve with that revision.
It's Councilman Ring.
I second.
That's Ms. Sikora. Revised roll call, please. Yes.
Yes. Yes.
Yes.
Thank you, Ms. Probst. Moving on, we do have, everyone at the dais should have received a copy of the cottage court resolution here that was decided on August 15th, 2023. Has everyone had a chance to review this document? And if
Yes.
there are no comments, I have a motion to adopt this resolution.
I'll make a motion.
That's Ms. Sikora. Second, please.
I'll second.
Ms. Chartowitz. Have a roll call, please. Yes.
Yes. Yes.
Yes.
Yes.
Moving on to our application portion of the evening. The first application that will be heard is number 23-006-PB, Kumar Realty, LLC, and who will be representing the applicant this evening?
Good evening, Mr. Chairman. My name is Jay Bone. I'm an attorney with the law firm of Schiller, Pittenger, and Galvin, PC, and I represent the applicant.
Good evening, Mr. Bone.
I intend to present three witnesses. Manish Kumar, who is a principal of the applicant, our engineer, Kathy Muller, and planner, Christine Cafone. And I will let them describe the application for you.
Very good. In the interest of time, perhaps we could swear in any and all witnesses that have not been previously sworn before in this board.
Please raise your hands. I, in your name, solemnly swear that I will tell the truth, whole truth, nothing but the truth, so help you God. Ready to roll.
Would you state your name and spell last?
Sir, if you could, just, the microphone, we're not only for this room, we are broadcasting our meetings live, so it's important for the audio. Thank you.
Counsel, you might want to make it kind of directional too, so when your client's testifying, there you go.
I think you're going to get another one.
Testing.
Manish Kumar, last name Kumar.
And Mr. Kumar, are you a principal of Kumar Realty LLC?
Yes, I am.
Okay, and just generally, because we'll go over details when the professionals testify, what are you asking the board to do?
I'm looking for a minor subdivision of the lot.
And what do you want to do with the resulting lots?
So build 2 house, central hall colonial, 5 bedroom, 3 car garage. That's the basic.
On each of the resulting lots?
Yeah.
Now, there was an engineering and planning review that asked about the possibility that there would be underground tanks. Did you have a tank sweep performed before you bought the property?
Yes, I did, and nothing was found.
And did you also obtain an owner's policy of title insurance?
Yes, I did.
And did the title search indicate the existence of any easements on the property?
And no, it didn't.
Okay, that was also requested in the report. That's all the questions I have for Mr. Kumar. The board has any questions? Or if you want to reserve for later.
And Mr. Bond, if you don't mind, perhaps we could also get Mr. Kumar's qualifications for the board.
He's a principal of.
He's the principal. Thank you. Does the board have any questions for Mr. Kumar regarding his testimony?
And I apologize if we're going to cover this, but I'm sorry, what was the square footage of the homes?
He didn't specify a square footage.
Okay.
We intend to present testimony that they will comply with the zoning ordinance. We're not asking for variances for coverage, for FAR, for height, for.
Understood. And I did not see in our packet, perhaps, do we have anything as to what the outside of these homes will look like?
No, we have not.
Okay. All right. Thank you.
Mr. Bond, it's my understanding that the driveway that is existing will be reused, at least as an initial point of access to the new lots. Is that correct?
That's my understanding, but I think our engineer would be
Okay.
discuss those.
We'll save all those comments for the engineer then. Okay. Any other questions from the board regarding Mr. Kumar's testimony? Any high-level questioning for the principal? How about from our professionals? Any questions?
Nothing for me.
Mr. Chairman, I did have one question. Thank you. Mr. Kumar, your survey, and this may be better asked of your engineer, but your survey has what is labeled as a storm shelter next to the existing dwelling. Can you describe what that is, and is it going to be removed if the application is?
Yeah, that's going to be removed.
That will be removed?
Yes.
Is it in, do you know what it is right now?
Right now, it's a housing water well.
It's,
Well.
there's
sort of-
the well is inside
Yeah,
that shelter?
yeah.
Okay.
So plan to, remove it,
So if the application is
It would-
approved, that well gets decommissioned
decommission.
and the
right.
shelter gets removed?
Correct.
Thank you. Thank you, Mr. Chairman.
And Mr. Burke, perhaps as well for the interest of the board. Is that shelter, is that an underground location? Okay, so perhaps if we need to speak with the engineer as well, we'll make sure that all remediations are taken care of at that point as well? Very good. Ms. Doyle?
Mr. Chairman, Mr. Burr and I did mention that on item number 17, and that we asked that if it's going to be removed, that should be noted on the plan to be removed.
Perhaps you could make that a condition?
Also, I think that the well will be private well. It seems that does that mean that the applicant will be going on public sewer? Because it appeared that he would be continuing with a private well. So that there should be testimony on that.
Very good. So I'm hearing we perhaps should make a condition of approval for removing or stating the removal of the storm shelter on the plan as the first potential condition. Second one being the, I'm sorry, Ms. Doyle, which number was the second one here?
Next one was number 18.
18, okay. About the storm shelter, very good. The private well. Okay. Any other questions?
I do. Can you describe how the lot's going to be divided? Can you describe how the lot's going to be divided? Okay.
Very good.
Thank you.
Are there any questions from our members of the public this evening regarding Mr. Kumar's testimony? Please feel free to come forward at this time. Please come forward, state your name and address.
Adam Alb, 2002 Washington Valley Road. How many square feet the lot is and how wide the lot is?
I can read what the plan says, but again, that's going to be our engineer who's going to be testifying next.
Okay, it's okay, yeah.
Provide those details. If you can wait till she comes up.
If we can defer your question until when the engineer testifies, that'll be okay? She'll probably answer it then.
All right, I thought everything is set, yeah.
The attorney testified that they're not going to be requesting, you're not requesting variances in terms of lot, are you lot size or anything?
No, the variances requested are lot size and lot width.
Okay, so we'll get the actual dimensions
We'll
from the
we'll
engineer.
get all the details. As long as you want her to talk, she's happy to.
That's exactly what I wanted to know. The lot size, the minimum lot.
The engineer has to put that on the record. So
Thank you.
it'll be up shortly. Thank you, sir.
Thank you. Mr. Bond, that closes that public portion of the meeting, or the, this portion of the application. We can proceed to the next witness.
Thank you.
Counselor, Mr. Kumar is staying in case we need him back. Mr. Kumar is staying in case we need him back. He's not leaving, right?
Good evening. Catherine with a C, Muller, M-U-E-L-L-E-R. I'm the principal and owner of Page Muller Engineering in Warren Township, New Jersey. I'm a licensed professional engineer in the state of New Jersey. My license is in good standing. I have a Bachelor's of Science in Civil and Environmental Engineering from Clarkson University. I've testified in front of numerous boards in the area, Warren Township, Watchung. It's been a minute since I've been here. It was quite a while ago. Probably dozens of towns and multiple counties throughout New Jersey.
You've been qualified as an engineer, as a professional engineer in those past applications.
Yes.
Most recently, where, ma'am?
My last was probably Fanwood in the beginning of August.
Hearing none, please proceed.
Thank you. Sure, it's block 418.02, lot 14. I'm going to be referring to the plans on my board. They're originally dated February 28, 2023, and they were revised 4/11/2023. These were all submitted to the board with no revisions to what I have. So what I have on the board is identical to what. They're entitled minor subdivision. So what I'll do is I'll work my way through the plans, explain the existing conditions, explain the subdivision, explain the proposed conditions. So the first sheet, we have our existing conditions. The orientation is with the road down, so north is facing down. The property is located in the R40 zone, and it's surrounded by R40 to the west, the south, and the east. And across the street is the P zone. There's a large vacant lot that's owned by Bridgewater Township. And they're all single-family homes with exception to behind us, the lot 16 to the south of us is the school, also owned by Bridgewater Township. The property is gently sloped all toward Van Holten Road. Our full frontage is along Van Holten. There is a ridge through the lot, so it's kind of at the crest of Van Holten, but all the water does run towards Van Holten under existing conditions. The property is mostly cleared. There's a wooded buffer to the west towards lot 15, and a little buffer towards lot 13, but the majority of it is house and lawn under current conditions. It contains a single-family home. The single-family home is served by public sewer and private well. There are no steep slopes per the township ordinance. There's no wetlands per the state GIS, and there's no floodplains located on this property. They're quite a bit to the west and quite a bit to the east. So if nobody has any questions about the existing conditions, all the improvements will be removed. We will be utilizing the existing curb cut for the existing driveway for one of the proposed homes. So I'm going to move to sheet 2 of 3. This is our subdivision plan. This is where we create our 2 lots. The existing lot area of lot 14 is 83,510 square feet within a 40,000 square foot zone. But you will see that we're asking for 2 lot area variances. Obviously, we exceed the 80,000 required for 2 lots, but we are proposing a 25-foot right-of-way dedication along the front. Per the tax maps, it's uneven. It's 41 feet, 41.5 to the east. It's 33 foot in total to the west. So we're doing a proper 25-foot right-of-way dedication for ultimate municipal road would be within a 50-foot. So that puts the existing sidewalk along the frontage within the right-of-way, which is certainly typical with a subdivision plan. So the 2 lot areas which we result in, proposed lot 1401 is to the east, 1402 is to the right or to the west. We have certified those lot numbers per your tax department that they are approvable. Proposed lot 1401, we're proposing at 38,370 square feet when 40,000 is required, and that's after the right-of-way dedication. And 1401 is 38,455 square feet, also after the right-of-way dedication when 40,000 is required. The other variance which we're seeking, so what we've done is we pretty much tried to equalize the 2 lots in area, but how we did the layout actually comes down to the lot width. So the required lot width is 150 feet. Existing, we're 265/66. So what we've done is it's measured at the front yard setback. So we did the offset for the right-of-way, and then we did the offset for the required 50-foot front yard minimum. We found the midpoint of that line, which results in twin lot widths of 132.25 for the resultant lot width for both. So again, we tried to even out the lot areas and also match the lot width. So one's not drastically oversized than the other. We cut it as straight down the middle as we mathematically could. We show the existing or the proposed setbacks on the property, which will be complying with all the other bulk standards other than the area and the width. The 50-foot front yard setback, 20-foot minimum side yard for one side yard, 50 for both, 75-foot rear yard setback. And then the next page, I'll go over the actual conceptual development for the lot coverage, the building coverage, the FAR, and all of that. So that's basically the gist of the minor subdivision. As you can see, the existing home is centered on the lot. That will have to be removed. All improvements will be removed before the deeds are filed.
Ms. Muller, if I have an old plan, mine just says that 1401 is 134.58.
It was on mine as well. I had it circled to ask.
An extra 2 feet,
134.56.
50, well, it says
Yeah.
58, but.
Yeah.
58 and then 132.25. We measured the lot width at the front yard setback. So the right property line and the proposed property line are parallel. So the frontage and the width are the same. The left lot is slightly skewed in. So when you move it back, it's
132.25.
it shrinks.
Which is why we have 120.66 at the rear of 02 and 132.61 at the rear of,
Got it.
yep.
Thank you.
You're welcome. So again, they're rectangular lots. As we talked about, the width is consistent on the right one, and the lot line in the back is slightly skewed, but we do result in two nice rectangular buildable lots. And just one other item, the Bridgewater lot density calculation, we've included that. The density of the area is decreased the more steep slopes you have for a lot yield. So as you can see, we have 0 steep slopes per the township requirements, and the overall tract for the lots permitted is 2.09 for the lot area.
Ms. Muller, perhaps having gone through 3 sheets, we could just take a pause and ask the board if they have any questions regarding these current sheets.
Sure, absolutely.
I do. On 2 of 3, I guess the one you have there, to the right of the proposed subdevelopment, we have lot 15-4-1802. Just curious, there's a series of lines with X's on the Chen property?
That's an existing fence.
Ah, thank you. And then also on Lot 02, existing utility pole overhead wires to be removed. Is that service going to the existing dwelling?
That's correct.
Okay,
And you'll see on the next page, we're proposing all the utility connections to be underground.
okay. Thank you.
Any other questions from the board while we're on this sheet?
I have, well, I'll wait till we get to the next one.
Please proceed.
So I'll switch to sheet 3 of 3. This is our conceptual lot development, soil erosion, sediment control plan. So what we've done here is we've done a conceptual development to show that these lots are proper for development amongst themselves. What we've shown on the plan are 2 single-family houses. The square footage of the footprint is 2,927 square feet, and the conceptual square footage of the house is 4192. So again, that's compliant with the FAR of 0.15. These are conceptual houses. If in the future a lot development, if that gets approved and a development application comes in that requires a variance or doesn't comply with any of the bulk zoning, they would be back in front of this board. We are not asking for any other variances in terms and related to the improvements on the property.
Sorry, does those square footages include the proposed decks?
They do not. That's just the building coverage.
Okay.
And will there be basements?
Yes. And I know in your professional review letters, there was questions about, was there any soil testing done? There has not been. There is a full basement on the existing house. Does not have a sump pump. So we don't anticipate any water issues.
Doesn't have a sump pump, and it's a dry basement.
That's correct.
Okay. I just want,
Good clarification.
because it doesn't have a sump pump, doesn't mean it can't.
It's not a walkout basement. It would be an indoor swimming pool. So there's no sump pump, and it is a dry basement. So we don't anticipate any issues. With the new homes, we'll have basements. We're proposing a 3-car side-loaded garage. As you heard, they're conceptually going to be 5 bedrooms, so 3 indoor spaces will satisfy the parking requirement. Per RSIS, it's 3 spaces for a 5-bedroom, single-family house. So I'll start with the lot on the left. Again, we have the side load garage on the left, and we're utilizing that existing curb cut. 1401, yes. So we have the side yard setback to the east of the property of 1401, one curb cut out to Van Holten, and we're utilizing the existing concrete driveway apron that's there today. We'll improve the driveway. We're skewing it a little bit to keep the house centered on the property and be side loaded. We have a minimum width of the driveway at 12 feet. Again, we'll utilize, or this one, it'll be connected to the sanitary sewer. We do have the existing lateral shown, and it does fall on that lot, so we'll utilize that connection for the sewer to the new building. And all the other utilities will be taken underground for their connections. The lot on the right, proposed lot 1402, which is on the western side, has an identical conceptual improvement plan. We use the same footprint, and we also have that side loaded on the left, similar to 1401. As I described before, we are at a little bit of a knoll at Van Holten. So we had taken into consideration, it's pretty flat out there, but we did take a look that the sight lines will be proper for the driveway location. The overall coverage that we have on the property increases the impervious for a total for both lots of 3,122 square feet. Our limited disturbance is under an acre, so we're not considered a major development per the state standards for stormwater management. So what we've proposed for this job is, it's a traditional design of 3 inches over the proposed roof. In this case, our 2 roofs are 5,854 square feet in total, which exceeds the increase in impervious that we're proposing at 3,100. So we think that is an adequate, it's a very traditional dry well system and standard solution for residential properties. I know there was a comment to design the property for the maximum possible impervious coverage. I am not a proponent of that for a single-family lot. If you're doing a major subdivision and you have infrastructure and you have a condo association, you know where everything's going and it's all designed. With a single family, we're doing conceptual right now. If somebody wanted to have a different shaped house, slightly different grading, Maybe owner A doesn't want a pool, owner B wants a pool. They don't want it right off their back, they want it in the back. All of those improvements would come through your engineering department and require stormwater management at that time. So I think what we've shown here conceptually with 3 inches over the roof is a suitable solution for a minor subdivision, especially considering that all the runoff from the sites go out to your municipal road. It does have inlets and pipes in it, so we're not redirecting any of the water from our property onto any of the neighbor's property. We show sufficient soil erosion and sediment control devices for the Somerset Union, SED. We show 3 replacement trees. That was one of the revisions that was added into the plans when we got the first round of review comments from your planner and your engineer. There was also a comment that each property will require a street tree. We'd be agreeable to that as a condition if the board approves the project. As far as type and size, we'll work with your professionals. If there's a list, I think there was a list back in the day, we're happy to choose from that, or whatever guidelines that they require. As you've heard, we will have, both lots will have a new well drilled. We've conceptually showed them off the back of the driveways for access if they ever need maintenance. The house on 1401 will utilize the existing public sanitary lateral, and then 1402 to the west will have a new lateral constructed. We got feedback from your sewer department asking for different details, and we'd be happy to add those to the plan, again, if it moves forward as part of compliance.
So 1402 will have a well and 1401 will be public water?
Nope, they'll both be well water. We did talk to New Jersey American, and the closest water main is 2,000 feet to the, I forget if it was the east. I'm a little turned upside down because of the,
West, I think it might be to the west.
it's out to, let's see here. I have their map here. I apologize, I'm just looking for my note where I wrote it down.
Is it towards Meadow Road?
Excuse me?
Is it towards Meadow Road? That would be west.
I have something with the C. I have it in my
Country
notes, I
Club?
wrote it down earlier.
I'm hard. Well,
Here we go.
you have Van Holten School, right?
Carleen Drive. So it's 2,000 feet down Van Holten
That
to the
might-
east.
Now, but you have right behind this a public school, which your property, this piece of property butts up against the Board of Education's property.
Correct.
I am hard-pressed to believe that there is not public water on the school board's property, operating a school on a well.
I can share this, and we can certainly put it in as an exhibit. We have the water main locations from New Jersey American Water.
Okay. We'll need a reference.
Council, it's going to be part of our testimony. Let's mark it and make sure that it's in.
Sure, this is just a snippet of New Jersey American water infrastructure. So, A1. And today's the 5th. So, on the other side of the school, I don't have the road that the school backs up to. On the back side, there's single-family homes, and I can't read the road name, but I can pass this along.
Spring Valley Drive.
Stony Brook.
No, it's Spring Valley behind, yeah,
Counselor, do you know the address of the existing dwelling on Van Holten Road?
386.
So I'm looking at their map, I don't have the full tax map. If they have an easement out the back of the school, there's water mains in that road. So it would be the school here, then single-family residential, and there's an existing main in that road behind, on the other side of those single-family.
Wouldn't be, well, it's got to go all the way into Spring Valley.
Mr. Chairman.
Mr. Burr, please.
So off of Stony Brook, there is a walking path that leads to the back of the Van Holten School. Through that pathway is an easement for the water company that has the water main coming off of Stony Brook, going up under or adjacent to the walking path.
So is there not water on Spring Valley for the single-family homes on Spring Valley?
I don't think so.
Okay,
No, for sure, Councilman.
There is
Gotcha.
not an existing main on Spring Valley.
okay. That helps clarify. Thank you, Bill. So it comes, and the other piece of that is, it would mean it comes in on the wrong side of the school from this proposed subdevelopment.
So this is the existing mains, and then the school, we're right here. Then the school, then houses, then a main.
Okay.
And the path that Engineer Burr's
Yeah.
referencing is coming down here.
Yeah. Now, I was thinking on the Spring Valley.
There's that path, right there between the two properties. Yep. Thank you.
Whoever ends up with that should just, to Nancy.
Just a quick question. You mentioned that the existing driveway that's there today, I heard you say was concrete. On the existing structure today, that's a gravel driveway, is it not?
Under current conditions, yes.
Okay, so that will be paved once it's
We're
utilized?
proposing an asphalt driveway
Okay,
for both.
for both, okay. And as far as the existing water service to the existing structure, it's a well that's encased in that storm shelter?
Correct.
And that's going to be fully filled, decommissioned, and 2 new wells will be drilled, one for 1401 and one for 1402.
That's correct.
Okay, thank you. That's all for the moment. Thank you.
And just to reiterate, the sanitary sewer public main is within Van Holten, and the houses will be connected. So that about wraps up my testimony. I just will go through your professional's report real quick to see if anything I missed. So again, there's no wetlands on the property, that's number 5. Number 6, there's no easements per the title report. We agree that all utilities will be installed underground. We would, as a condition of approval, have the corners set at the outbounds and the new lot line. We do have the 3 replacement trees shown, type and size, per your professional's recommendations. Any trees that are damaged will be replaced. We'll add a note to that effect. As I stated, there hasn't been any soil borings, but the condition of the basement, the house is not a new house, it is dry and adequate. Number 12, we'll add a note per the existing sidewalk, which is along the whole frontage already. The driveways will be paved. We'll add a detail for that pavement. We'll add the 1 street tree as required or noted here, along with the detail for the tree installation and the planting details with all the parameters listed on the review letter. 17 and 18 are regarding the well, and we've already testified that we'll comply. Number 19 is for the stormwater. I'm asking the board to consider the 3 inches adequate, and when the plot plans come in, they'll be to the review of your engineer, rather than the maximum impervious at this time. 21 and 22 are statements. And again, we're all pitched out to the municipal road. We're not redirecting any drainage to our neighbors to either side nor uphill. For number 22, they did do a tank sweep and none were found. 23, the applicant would comply as it moves forward. 24 is the construction mitigation, which I reviewed with no objection to agreeing to that section of the ordinance. Compliance will be done for the subdivision per a resolution of approval for everything that I've stated and our other applicants or our other professionals have agreed to. And I didn't see any other, the traffic and safety were deferred to your engineer. The fire official has no objection. And the sewer or director of municipal services and the sewer utility will comply with all of their comments for details. So at this point, I'd like to take questions from the board for sheet 3 of 3.
I'd like to open to the board to any questions, Ms. Muller, also including the exhibit that she just passed around to us.
I have one. Has any consideration been given to electrical vehicle charging stations in the garage?
We did not get into building permits, so it has not been taken into account. It's not required per the state law for.
I understand it's not required, but.
It's not an unusual element to see in new homes, but I'm not saying we will put them in.
It's something that's coming.
Understood.
I have a couple questions. So I viewed this property, and I know there's a lot of mature woods, trees on the sides, which are very nice. On your page 3, on the left-hand side there, you show some woods line, but then there's a little bit of a gap before the curb line. Am I viewing that correctly? Yes. Okay. And the intent is to keep, you're going to keep, or make sure there is that, I guess what I'm looking at is somebody's coming out of the driveway who's trying to look to the right. I want to make sure.
Maintain the sight distance.
Yeah. I want to make sure there's a sight line for cars coming out of that driveway.
There's no, we can ensure that we won't put the street tree there.
Okay.
We can put it elsewhere along the frontage, so it won't be an issue.
And I think likewise, you want to make sure at the other side, someone coming out looking to the left, the sight line for people exiting the driveway.
Correct, and that's why we kept it
Yeah. And then,
the interior lot line.
okay. And this may be more of a question for Mr. Burr, I'm not really sure. I understand that in the current situation, no water flows onto neighboring properties, so there's no concerns there. I'm not sure that I like the answer that it flows onto the township road, and therefore, it's not a problem.
Well, we are mitigating it. We are collecting more than what we're increasing it by.
Okay. How feasible, from an engineering point of view, and whether it's one or both of you, could this water that flows towards the street be collected and it looks like a relatively short pipe run to dump that into the dry well? Is that something feasible? I'm asking both. I'd love to hear from both of you.
Yes, I believe it is feasible.
Is that something we would want to consider asking from an engineering point of view, or is it not necessary?
It has certainly been the practice of this board on similar recent applications where we've had variance requests to ask for additional drainage above and beyond.
Yeah.
Especially in light of what we saw happen
Yeah.
7 years ago. What's coming through the pipeline regulation-wise?
Yeah.
You may not be able to capture all of the driveway depending on, the elevations.
Yep.
Ms. Muller would know better, but certainly you could capture some of the proposed driveway areas in addition to the roof areas and really button this thing up.
Would you be willing to work with our engineer on that?
Yes. The only thing that I do caution boards, and I do stormwater every day, especially on single family. And I know Mr. Burr and I have talked about this on a recent application, not in front of the board. I don't want to surge the tanks and actually create a concentrated discharge. So there's a happy medium into piping everything and having it shoot out one location, and having it also be able to sheet flow across the front yard. So I'm happy to work with your engineer when we come in for a lot grading plan. The house may change, it may move back, they may want it lifted. We're happy to work with your engineer to come up with a solution.
And, you know, I'm not an engineer, and I don't purport to be one, and that's why I kind of asked the question. And as long as you're willing to accept a stipulation that says, you know, you'll work with the engineer to see what can do to collect water so it does not run across the road. And I, you know, obviously that has to be wordsmithed, but I'm happy with that.
Thank you, Councilman.
Yep.
Any other questions from our board?
I do. I know you testified that it's a conceptual homes at 4192 square feet, and that it currently meets the FAR and impervious coverage percentage. That's off the lot size of 40,000, or the minimum lot size of 40,000 square feet, and the second variance of the minimum lot width. These homes are pretty big, and I can assume they're going to want the deck like you have proposed on the back that you said is not included in the 4192, right?
I was talking about just the roof areas that were collected to the dry well. We do have 300 square feet per lot for other, which would be the front walk and the deck.
Okay, and the deck.
Yeah.
Right.
And I just want to clarify, the allowable numbers that we have on these lots that I show in the zoning chart on sheet 2. These numbers for the lot coverage and also the floor area have been sized down as a percentage of the lot area we're proposing, not at the whole 40,000.
Okay,
So they've all been scaled down proportionally.
got it. Thank you for clarifying that. Is the 3-car garage included in that 4192 that you spoke of too?
That's strictly the footprint of the house, that if you put gutters on it, that's what I'm directing to the dry well.
Got it. Thank you.
Sure.
Thank you, Ms. Sikora. Any other questions?
Just a comment, and, you know, one of my, I'll say, concerns with this application, I think, you know, it's very difficult not knowing what the homes are, you know, what they're going to be. And I think we want to make sure that whatever the overall design of these homes are blends in with the area. You know, you have an older home, understood, seen the house, I understand what you're trying to do. We also want to make sure that, you know, we don't have two monster homes that stand out in the neighborhood as opposed to all the other homes in the area. And that's the hard part that I'm wrestling with, because we don't know what these homes are going to look like, because we don't even know if they're going to be where they are proposed on the, you know, there's so many unknown questions, so.
Just as if somebody came up for a knockdown on an existing lot. Our presentation tonight and my testimony is it will comply with the zoning.
Understood. Complying with the zoning and blending with the area might not always align.
We did take a look at the subdivision, which was just to the west of this.
Yep.
And those are substantial homes. They have 3 cars, side-loaded.
I think there's a definite difference between the homes on Van Holten versus Spring Valley.
It was actually the one to the west, Brenner?
Yes, okay. Yeah, those are relatively new as well.
There's no way we could have an indication of the type of architecture that's proposed or that's being considered for this. Some of us drive that road every day to drive our kids to school. We're familiar with the area, with the surroundings, with the neighborhood. It's one thing to have a cul-de-sac or to have a road that's off the main road there, but I think it would help the board to deliberate if we had an understanding, and I think I understand what the limitations are for today, but
I didn't catch the first thing of your statement.
Can you bring them back for final site plan? Grant preliminary subdivision, but bring back final site plan? Final, hate to do it, but
I think seeing the two variances, really one of the main points here that we're trying to make is essentially you want to make sure the homes are within character of the neighborhood.
correct. Yeah. And we have the ability, because there's variances, we can do additional requirements that if there was no variances, we wouldn't be able to.
Board Attorney, Mr. Steinhardt, could we make that a condition?
Which piece?
Essentially having them return for a site plan.
You know, you grant preliminary today and make it come back for final. Well, you'd consider preliminary, make it come back for final. It's a minor, so no. Nope. But if you are conflicted on, you know, what these conceptually look like, that's an issue for the board. And, you know, the applicant may be asked to bring somebody back, bring an architect, bring somebody back in and give you some additional testimony so you can consider what parameters you might want to grant. It's entirely up to the board's discretion.
Okay, comments from the board?
I would certainly welcome it. Additional testimony on some conceptual designs. You know, I think even just the number of ranches on that street versus two and a half story homes, 3-car garages is, you know, Benner is one piece of it. I'd love to see a proposed color rendering of a home.
What are the thoughts from the board?
I agree with that.
Council, you understand, I think, some of the concerns, right? I mean, you're asking for two variances in terms of lot size. The board has got some genuine concerns over what you may build there, and if you're gonna design undersized lots, whether the homes will conform to the rest of the neighborhood, since you can't answer those questions. Sensing that they, you know, in lieu of a vote that may not go the way you want, they may want to hear something additional from you in terms of what these may look like.
I understand the board's concern, and I'd like to get a little bit further.
Yeah, of course. I just want to plant the seed so you can sit there and think about that as we're progressing.
I think it's worth going through and see if there's anything else. I mean, if they're going to come back, let's flush everything out.
Perhaps with the subsequent testimony, we could have some more questioning. Okay. Ms. Muller, does that conclude your testimony?
Yes, it does.
Very good. Any other final questions for Ms. Muller regarding her testimony from the board?
Oh, you professionals may ask questions.
Please, Mr. Byrd.
Thank you, Mr. Chairman. The existing sidewalk that is along Payne, have you reviewed that, and what kind of condition is that in?
I personally did not walk it, but we look at everything street view. It looks in satisfactory condition, but if anything gets damaged, or if there's any lips, it'll be improved, and I can put a note on the plan.
Just to clarify, do you use Google Street View?
We use that, we have Bing, we have
Just,
LiDAR.
the only reason I bring it up, I was looking, actually trying to find the closest fire hydrant before on Google, and based upon some of the signs that are along the street, they are very old images that Google has for that street for whatever reason.
There's actually one I found, it was bright white, brand-new concrete, so that's why I questioned it, and I looked at more sources.
Yeah,
And it looks a little older from another street view.
okay, yeah. Just some of the Google images are,
You gotta
there's
see-
some political signs on the, it was a campaign season for school board election, and there's some
Right.
very old signs there.
Yeah, gotcha.
So any damaged sidewalk would be repaired,
Yes,
and any sidewalk that would need to be removed or impacted to install utilities would be repaired in kind
correct.
as well? Okay. and you had testified on lot 1401, you're proposing to reuse the existing sanitary sewer lateral, I guess, at the right-of-way, and then reuse the lateral that goes under the road. Would you?
That's correct.
Would you have any issue with televising that, cleaning it out, and making sure it's in good repair
No,
as a condition?
no objection.
Very good.
Any other questions?
All I have. Thank you, Mr. Chairman.
Thank you.
Yes, I have a couple. First of all, I'd like to commend you for accurately explaining how to measure a lot width. There are not many that do that, and I want to commend you for that.
Thank you. Thank you.
One thing, however, in your testimony seemed inconsistent, and I'd like you to have an opportunity to clarify that. You mentioned that the minor subdivision was designed for a stormwater system that meets the smaller character of impervious coverage, which is lower than the requirement. And then you also say that relative to the floor area ratio, it is smaller in terms of FAR than what would otherwise be required. You pointed out the 12.7 and the 0.11 for FAR, and you justified the stormwater based upon the fact that if somebody wants to come in the future, presumably the engineering department will require more stormwater management, even though it's a minor in terms of degree. So with that being said, you also said we will conform to the ordinance. Now that differs from the fact that you said we're making everything smaller. So are you making everything smaller, and are we limiting the impervious coverage to 12.7%, or are you relying on the zoning ordinance, which permits it to be much larger?
The statement that I made was that the coverage, for what I heard from Ms. Sikora, and a 40,000 square foot lot with the coverage. The percentages for lot coverage and the requirement for FAR are a percentage of the lot area, not the lot area for the requirement for the zone, but the lot area that we're proposing for the two lots.
Understood. You characterized the degree of stormwater design and the largeness, the greatness of that design, based upon the fact that your maximum impervious coverage was at 12.7. It's smaller. My question to you, I'm probably repeating it, but in a different fashion. Are you suggesting that your lot will be maxed out, permitted to be no greater than 12.7%? Or are you going to rely on the maximum 18%, which is afforded you in the ordinance?
Neither. Right now, we have a conceptual development. We think it fits the neighborhood. We looked at impervious coverage existing and proposed. We have proposed a dry well, which will catch 3 inches over the proposed roofs. And just for testimony today, under conceptual conditions, we're collecting more than what we're increasing. I did not testify that we will not exceed what's shown on our conceptual development, but we will be within the parameters of the zoning.
So if I can answer, if I hear the answer, then it is they're not conceding that it's 12.7. They acknowledge that they're going to have to be, that they'll be constrained by the ordinance.
Understood. And with that, I would, as a planner
what I
now,
hear you
I would
saying.
recommend that we use, because we're not certain that engineering will have an opportunity to pick up the nuances that occur over time on single-family homes. That's our problem, is the single-family homes adding up. I would encourage the board to consider giving the township engineer the authority to increase the need for stormwater management up to, but not exceeding, the 18%. But now, okay, back, you indicated that based upon the title survey, there are no easements. The title policy, there are no easements. Did you get a 60-year on this, or what did you get? How far back did you get from?
I'll defer to our attorney and the applicant.
You did a survey on that, right?
I said, as you've heard, there was a title search, because that was questions for Mr. Bone and the applicant.
Did you create a survey based upon a title search?
Did I? No, there was
Did a surveyor?
I did not review the survey, nor did I do or oversee the survey.
Okay, I would recommend that, that the attorney for the applicant just simply state there are no easements based upon a 60-year title search. I mean, make it simple.
Counselor, you okay with that? Counselor, you okay with that?
I did not represent the applicant in the purchase of the property. I have been provided with a copy of the owner's policy. And the owner's policy does not identify any specific easements. I will say that it contains some kind of wishy-washy language that it's subject to.
The legal term, wishy-washy?
From one lawyer to another.
It's a problem I have with title companies that they want you to tell them if there are any homeowners associations. Aren't they supposed to do that search? But schedule, and I can have Mr. Kumar authenticate a copy of his title policy and provide a copy to you as an exhibit. Schedule B2, exceptions from coverage, does not identify any specific easement, as I said. It does, however, to be completely candid with the board, says as number 12, subject to restrictions, reservations, or conditions of record, but omitting any such covenants or restrictions based on race, color, religion, sex, or national origin, if any. But their search did not disclose any easements that they called out in Schedule B.
Mr. Kumar, since he's still here, did you had a survey done, sir?
Survey was done in the buying process before title was completed.
But was a survey done?
Yes.
Would you be willing to provide a copy of the survey to the township engineer and the township planner? You have it? Okay. But it does not provide that, what we're looking for.
One of the notes is, it states, subject to easements and restrictions of record. So it doesn't.
Okay. So we have some inconsistency there with the survey.
No, the surveyor didn't make a decision whether he didn't vote. As I'm understanding the description. It's not inconsistent with anything that we have presented.
I leave it up to the attorneys after the fact to just to confirm that there are no easements that would affect the development of the property.
Works for me.
Yeah, I have a note. I've made a note.
And the next question is, the GIS information says there's no wetlands. Now, wetlands are a 3-parameter approach. You don't call it a wetland unless it has all 3 parameters. The proof that was given that there's not going to be a wet basement is that the existing house doesn't have a sump pump, which may be fine, and may not be a wet basement there. But it would not be difficult to ask the engineer to simply put down the soil characteristics that are in the documents. We've got them all over the place. So she can put down what soils are on the property, put a little map on, and we can check to see if there's a high water table in any of those areas where the future houses are going to be going. So it's not much I'm asking.
We actually do have the soil types on the cover sheet.
Okay.
So it's KKOC, and that encompasses 95% of the lot, where the existing house is, and also where the proposed house is.
Would you happen to know, and I'm pushing you beyond what my original question was, would you happen to know whether or not there are any high water characteristics above 8 feet?
I do not know.
Okay, well, maybe we can have that if she comes back. We can
Recognizing it's not a major stormwater application, would soil sampling be,
Soils would help because if they have a detention basin or a seepage pit and the high water table is at 4 feet, it may not function correctly.
and there've been no drilled soil samplings that have been taken or anything like that?
That's correct. It's typical that we would agree to do a soil sample when a machine is on site. 'Cause
Drill for wells.
So typically when, we're going to submit grading plans for approval for your engineer. Depending on how it all lays out and how it grades and how much driveway I could get or what's required and in compliance with your engineer, I may move this dry well. There's a couple I don't want to put it by my basement. I don't want to put it uphill. So what we typically would agree to in a position like this is to do a soil test when a machine's on site to certify that what we've designed for the ultimate house and development will function. The seasonal high water table, what's the permeability, and we have a lot of tools in our toolbox to satisfy stormwater management on a single-family house. There's a lot of different products now, from stone to concrete to arches to, there's a lot of different products that they're developing every day. And we adjust that after we do the soil test. The only thing we ask is that we defer to the machines on site versus going out and digging down. We don't know what the final location is. It saves a machine going out there, digging it up and disturbing before we start construction with the soil conservation and have the silt fence up and everything else. So we would be amenable to doing a soil test to prove the ultimate design.
All the questions that I have are answered. My last question, however, is there anything from an engineering standpoint in this report that you cannot agree with, or could you comply with everything from an engineering standpoint in Mr. Burr's and my report?
So again, the only item which I defer to the board is number 19, and that is regarding the stormwater for the maximum impervious. I just don't see it as practical when we're just doing a single-family house and we don't know what amenities somebody may want, what elevations they're going to get at, to get things to one system. The stormwater regs are forever changing. I've been through a number of them in my career. So it may be different if somebody comes in and puts a pool in 10 years. And then it won't be adequate anymore, and they still have to do more. So we comply, and we take no objection to the review letter, with exception to the doing stormwater management for the maximum improvement.
Thank you very much.
Thank you, Ms.
Thank you.
Burr. Board Engineer, Mr. Burr, after having heard Ms. Muller's testimony, essentially, what are your comments, if any, regarding the impervious coverage situation?
I understand certainly where the applicant's engineer is coming from. On these small lots, sometimes it is, although we do have a number of ways to manage the runoff, sometimes it can be tricky to get drainage in to the maximum, lot coverage. But on the flip side, from my perspective, from Ms. Doyle's perspective, what we have before us are conceptual plans, as we've heard, that have home sizes that have not reached that maximum level. So theoretically, depending on the FAR and the coverage limits, these homes could be probably 1,000 square foot bigger and still comply with zoning than what's shown here now. I wouldn't want the board to miss the opportunity to manage that additional runoff if in the future, when these plans get tweaked or finalized, if they come in with bigger homes, we have to make sure that we're managing that. So it's,
You'd concede, Ms. Muller, wouldn't you, that if you're asking the board to consider an application with some significant uncertainties in terms of, your ultimate proposal, that if there be prudent stewards of Bridgewater, that it would be in the community's best interest and the board's best interest to leave that open-ended too? Be as
So we've designed to 3 inches over the conceptual roofs. If the roofs get bigger, the dry well will get bigger. We'll do 3 inches over the proposed roof.
now, we also, though, heard some testimony that you would
Try and get
agree
some of
to
the
try to
driveway.
maximize the drainage. So from my perspective, or whoever is going to be reviewing this on behalf of the township, I think we need to have some idea of what that number is going to be. If it's not 18%, is it going to be 15% of the lot would be managed? I think some,
We know it's not 12.7, we know it's not going to hit 18, but we need to come up with some kind of compromise to make sure that this water's not pouring across Van Holten Road in a heavy rain, washing out the blacktop,
Or icing over the road in the middle of the winter when the.
or
buses are
icing
going.
over the road in the middle of the winter, when we go through melting, freezing season.
candidly, if you're the board, that you're almost forcing their hand to be as, to over-design, to require you to over-design it in order to address whatever the contingency.
The alternative is if we knew more about the homes and what they were going to do, we could,
We're a minor subdivision that we're asking for, and I understand that there is some unknowns, and we have conceptual developments. Just as if it was a major subdivision, we don't come in with a house for every lot. What we will be required to do is not develop the properties per my conceptual plan, but have a real house, have real numbers, have real stormwater management. I'm not saying this is the end-all be-all for the stormwater management for these lots, and we're not going to add anything more. If somebody comes in and wants more driveway or more impervious, that's all going to be reviewed by the engineering department. The only thing we're stating here is we are going to put stormwater management in to the satisfaction of the engineer, and we're not asking for any kind of coverage variances.
Any other questions for Ms. Muller?
I just have a comment. Is there any precedent in the R40 zone of variances like this being granted? And has that happened before? Which lots are they? And what are the sizes of those homes on it? What is the impervious surface? Like, again, this seems to be a pretty big concern on those ones, if there are any that have been granted in the past. And, which properties are they? I don't know if anybody has an answer, Mr. Chairman, to that question I have, but that's what's on my mind. What is the precedent in this residential district where the lot sizes are smaller, the houses are a lot bigger? And I don't have the answer, but that's what's on my mind as I'm listening to everybody. What's the history in this R40 zone? Councilman mentioned, again, the aesthetics of the community, the look of that street. Are there small lot sizes in this zone that this board has granted variances to in the past? And what are the houses on those properties?
well, I think to that point, just to clarify though, too, they did mention Benner Court, which is just down the street. Little bit different of a situation because it's not right on Van Holten.
Right.
It's on a cul-de-sac of, Miss Benner, after she passed away, her property was subdivided, homes built on that street. So it's a little bit different of a situation. So when we talk about the area, I think it's important to apples to apples.
And we will have planning testimony that may address some of your questions.
Okay, that's what's on my mind. What's the history?
Any other questions?
I have a comment, because you keep mentioning that, you're not sure what's actually going to be built. Like someone might want more driveway or more of this. And my comment, I guess, is is the client actually buying the lot to split it and then to build like a conceptual house? Like the footprint that you have, is it like a house that has already been built, that he has a concept of, and possibly, you know, okay, we have this concept, we put it up for sale, this is like what people think, you know, okay, I'm gonna buy a house that looks like this. And then they can come in and make some changes, but usually they don't make that big of changes. So I guess that's kind of my comment, just thinking of how the whole process works.
When we do the conceptual, we're in a realistic world. I don't show a, 1,600 square foot footprint for this house. So these are other houses that were built elsewhere. They're footprints from other jobs on equal lots. And it's basically, a practical house. It'll fit on the proposed lot, even though we're undersized in area and width. It's an adequate house. It's going to be within the regulations and the bulk requirements for the zoning. It will 100% comply on that scaled down lot and width. We'll still have the same separation from our neighbors. We're going to comply with the side yards. We're going to have the same percentage of coverage afforded to any of our neighbors. So, and again, we do have a planner here tonight, and she'll talk to, the suitability of the lots and the variances that we're seeking.
Thank you, Ms. Muller.
Thank you.
Other questions from the board? I'd like to open to any members of the public that wish to address Ms. Muller. If there are other questions, questions can be held until all testimony has been heard. Okay, that closes the public portion of this section of the application. Mr. Bond, any other witnesses?
Good evening.
Good evening.
For the record, Christine Nazaro-Cafone. I'm testifying this evening as a licensed professional planner. I've been qualified here in Bridgewater and over 450 or so planning and zoning boards throughout the state. I teach planning and zoning courses at Rutgers Center for Government Services. My licenses are current and valid. I'm also a court-appointed affordable housing special master, and I testify on a regular basis.
Does the board have any issues with Ms. Cafone's qualifications? Hearing none, please proceed.
Thank you, Chair. So the application that's before the board this evening is a minor subdivision to create two lots of relatively equal size out of one lot that is 83,510 square feet. We're seeking two lot area variances for the two new lots, proposed lot 14.01 and 14.02. The R40 zone, where the subject property is located, requires 40,000 square foot lots. Even though our existing lot at 83,510 could be split in two and two conforming lots would result, when you do the right-of-way dedication that Ms. Muller talked about, we lose 6,685 square feet of our lot area. So what that does is it puts us into a situation where we are now deficient with our lot area. So lot 14.01 is proposed at 38,370. 14.02 is proposed at 38,455. So just under by about 1,600 square feet or so, the required 40,000 square feet, despite having the 83,510 before the subdivision. So those are the two variances for lot area. To be clear, when we subdivide that lot, which has 265 linear feet of frontage along Van Holten, we are doing it equally. The line is essentially being drawn down the middle of the lot, and what happens is the resulting lots, instead of having 265 feet of frontage for one lot, we have two lots with 132.5 feet of frontage. That frontage just gets split between the two lots. This R40 zone requires you to have 150. So those are the variances that we're seeking. In this particular zone, you are required to have a front yard setback of 50 feet, a rear yard setback of 75 feet, a minimum side yard setback of 20 feet, and then a combined side yard setback of 30, or a 50, excuse me. So you could do 25 and 25, you could do 20 and 30, you could do 28 and 22, but those side yard setbacks have to equal 50 unless you would need a variance. So while the board doesn't have a plot plan exactly tonight of what we intend to build, what the applicant is testifying to you is that the resulting dwellings, if the board were to approve the subdivision, would be in what's called in that building envelope. So when you apply those setbacks to the newly created lots, you create the building envelope, and the structure is going to fall somewhere within that. So what that tells you as a board is that the setbacks, the rear yard setbacks, the distances to the sidelines will be consistent with what was envisioned in accordance with the zoning. So the board has two mechanisms in which you can grant C variances that we're seeking tonight. You can grant them under the C1 statutory criteria if there is a unique piece of property or something unique about the lot with respect to the shape of it, with respect to the topography. This is a pretty even lot, so it's not really unique shaped as far as the actual topography, but certainly that right-of-way dedication creates a unique circumstance impacting our lot, right? If we didn't have to do with that right-of-way, we would have a conforming lot. So I think the board could certainly invoke the C1, at least with respect to the lot area. In the absence of any hardship under the C1 statute, the board can grant, if you find that one or more purposes of the land use law is advanced by the grant of the application, you can invoke the C2 section of the statute, which is really the flexible C. So you would have to find, though, that one or more purposes at 40:55D-2 in the land use law. Those aren't unique to Bridgewater. I didn't come up with them in my 28 years of practicing. They come right out of the municipal land use law statute at 40:55D-2. Statutorily, we would have to advance one or more of them to meet the C2 flexible C criteria. So the one I think the board can look at is criteria E, which talks about an appropriate population density. Now, our board member, I think it's Mr. Eck on the end, asked about precedent, right? And that is a cringy word for planners because we don't ever use that. We don't ever say there's a precedent because we don't like to testify, or we shouldn't be testifying, and your board shouldn't be evaluating variances on historical decisions. Each case has to rise and fall on its own merits. So that means that the board has to be comfortable, even if a subdivision was granted down the street, it might have different factors than this property. So, and each property is unique and has different, I've testified, while I've been before 400 boards or so, I've testified on thousands of occasions because there's lots of boards that I go to over and over again. And there's always something unique about every application. You can't really parallel one application to another. So each has to rise and fall on its own merits. So from my point of view, when I'm testifying as a planner, we could focus more on the character of the area and what that area looks like, which is properly why the board members ask the questions. Well, don't just tell us what's going on Brenner and Reagan, some of those newer cul-de-sacs that you don't see. Tell us what it's going to look like on Van Houten, because that's what we're going to see when we drive down it. So when you look on Van Houten and you look at the subject property, there are 6 lots, between going in an easterly direction, so towards Country Club, between our subject property and Foxcroft Road. There are 6 lots to our east. Of those 6, only one of them is at 150 feet of frontage. The rest range between about 120, 129, 121. So only one lot, when you go to the east, the 7 lots till you get to Foxcroft, only one of them actually has the conforming 150 feet of frontage, and similarly, only one of them is about 40,000 square feet. The rest of them all hover in the high 38,000-ish that we're proposing. So certainly when you look at the 7 lots to our east along Foxcroft, we absolutely conform with the rhythm of that street because the lots, in fact, the unsubdivided lot at 265 feet of frontage along Van Holten is really out of character because there is not another lot along Van Holten that actually, along the same side, that has that 265 feet of frontage. Because after then you cross over Foxcroft and you're still going further east towards Country Club, when you get down to Carleen, there's 7 more lots to the east, and only 2 of them meet, of those 7, only 2 of them meet the required frontage of 150 and 151, right at the corner there of Foxcroft and Van Holten. You have a conforming lot, and then going 1 in from that, 150, and then when you're going down Van Holten further, those lots, when you get to the where you would turn in to go to Carleen, not a single one of those lots. There's 4 more lots there till you get to Carleen. None of them. They're all about 120 feet. So that tells me from a planning point of view that even though the lots aren't conforming to the R40 zone, they're certainly consistent with the lots that exist out there on Van Holten. So I think the board can certainly consider the subdivision. I appreciate your concern about the size of the homes, wanting to be consistent with the character of the area, but in my opinion, the unsubdivided lot, I did not see a maximum habitable floor area for the R40 zone. So at 0.15 FAR, you could build a pretty substantial home on the unsubdivided lot that is not really consistent at all with the character of the area. I mean, based on what I saw out there, the homes on Brenner, the homes on Reagan, so some of the newer homes in the area are definitely larger than some of the older homes out there. It's a mixed, if you will, of some older homes. There's some ranch-style homes out there. There are definitely the newer homes are along the cul-de-sacs, like I said, on Brenner and Reagan, and on both of those streets, they have exclusively 3-car garages. So there is a trend in the area, but I acknowledge that looks a little different because you have to go off the cul-de-sac to see that, so you're not driving Van Holten. But regardless of that fact, I don't think that the 2 lots that we're proposing, because they still have to respect, they're very consistent with the size of the lots in the area, and they will have to meet all of the setbacks, or the applicant would have to come back before the board. If we were violative of any one of those setbacks, the 50-foot to the front, the 75 to the rear, or the combines of 50 and minimum of 20, we'd have to come back before the board. So I think the board could look at the 2 purposes of the land use law. I think our criteria E, which talks about establishing an appropriate population density. It doesn't say a conforming population density. It says appropriate, which I think is appropriate based on my review of the tax maps and the size of the lots in the area. The subdivision is certainly appropriate. And then criteria G talks about sufficient space in appropriate locations for a variety of uses. Absent the lot area and lot frontage variance, this application before the board would conform in all other aspects with the bulk criteria, right? That's what we call the bulk criteria. The FAR, the setbacks, all of that is the bulk coverages. Those are the bulk criteria for the R40 zone. And the land use law then asks you as a board to evaluate that and weigh it against the negative criteria. And it doesn't ask you to hold us or any other applicant to a standard that there be no detriment, just that there be no substantial detriment on the impact of the zone plan or the public good. And I think with the resulting lots being so consistent with the established pattern along Van Holten, as well as the trend in this area, realizing that the newer homes are larger than some of the smaller, older homes in the area, I think the board can be satisfied that the subdivision would have no substantial detriment on the zone plan or the public good if the applicant were to the board were to move favorably on this application.
Thank you for your testimony.
You're welcome.
Are there any questions from the board?
Yes. I know you're surprised by that.
Just a bit.
So when you did that study looking at the lot widths along Van Holten Road, and the number of, I'll say, undersized or non-conforming lots that you looked at, how many of those lots had homes of 4192 square foot or greater?
So it's difficult. I mean, we could get the tax map information, the tax lot information for that. I would say that Probably not a substantial number of them are
So
over.
so you're not really sure, is what you're saying?
I'm not quite sure, but I
Okay.
did drive Van Holten, and I've certainly driven the area, and I've looked on it on Google Earth as well, but I don't have that number for you. And the
Okay.
reason I didn't prepare that number is because we looked more, the relief that we're asking relates to the size of the lots, not the size of the homes. And the size of the homes and the setbacks of the homes are going to conform to the zone plan.
Understood. But you're asking for some variances, and with that, we have some concerns. Obviously, you heard about the size of these homes and what they look like, and I'm just trying to weigh all of that.
I understand the question.
Thank you.
You're welcome.
Councilman Ring, I did look on Van Holten Road, and it looks like 414 Van Holten is a little bit over 3,800 square feet, and it's on a 35,000 square foot lot.
Sorry, what number?
414?
We have two relatively simple questions for you.
Sure.
There was no other way to address the right-of-way dedication and leave the lots, or one or more of the lots conforming?
I'm sorry, I don't understand your question.
There was no other way to address either the right-of-way dedication or to do the lot layouts so that instead of having two non-conforming lots, you could only have one?
Well, the right-of-way dedication, there's nothing we could do about that, because that stretches along the entirety of our 265 feet of linear frontage. The lot area, we could certainly eliminate, we certainly have enough area to create one 40,000 square foot lot, right? If you're creating the combination of our two lots after the right-of-way dedication is 76,825 square feet.
To make it easier for you, I guess
We could make one conform, right? Because if we have 83,510 square feet to start, we lose 66,885 for our dedication. That leaves us with 76,825. The zone requires 40, so we could create 140 and one at 36,825.
testimony that this is the optimal way?
I think it makes sense to create the two. It makes them more even. It makes the lot pattern. It follows the pattern along Van Holten more closely if we subdivide them down the middle.
Any other questions? How about from our professionals? Any members of the public have any questions? I close this public portion of questioning for this part of the application. Mr. Bond, do you have any more witnesses?
No, Mr. Chairman, we don't have any more witnesses. Perhaps this would be the time, excuse me, the time to discuss with the board. We've suggested that you may want some more information for us to come back, and I would like some guidance in terms of what you would like to know, what you would like to see.
I think the board would be interested in seeing a potential rendering of the type of architecture that'll be proposed. Understood that we're not at that point where there's a structure. Any other comments from the board?
Yes. Engineer gave some testimony that, when we were talking about water runoff and stuff, if it's a larger home, they would increase all of that. I'd like to have a better understanding. I understand some of this is speculative on the development of these homes, but to say, okay, we're going to agree not to build larger than X home, square footage-wise. Understanding that, yes, based upon this piece of property, there's certain things you can do that are conforming, subject to us giving you those variances. And I guess I just want to make sure that by giving you variances, we're not giving you a blank check to build homes that are not appropriate for the area. So if you said, hey, we're going to commit to no more than, first floor square footage of X, from an FAR point of view, no higher than Y, no larger total square footage kind of thing, I would feel a little more comfortable having an idea of, I heard testimony that these lots were taken and these proposed from designs are taken from prior developments. I'd love to see what this template home looked like in another development. Does that help any? Okay.
I feel it's reasonable, especially given that we're in a unique situation in which we have a Board of Education piece of property. We have a school behind us as well.
What, the school's behind it, and what?
Correct. I'd like to see exactly what the structure, the post-structure, potentially may look like with the, right?
So that's another reason, not an additional
No,
ask, but
correct.
another reason for it.
Right.
I think we all understand that we're both operating within certain parameters, and the board can only make certain requests. But I think if I'm hearing what they're saying, we just want to get a sense, not necessarily trying to be overly restrictive or tie you to something, of what it may look like if we're going to go so far as to create these two undersized lots. That's all.
And to the,
Do it or not do it, entirely up to you. But I'm sensing, I think it would be helpful for them from a deliberative perspective, counsel.
So I've written down, you'd like a rendering showing a type of architecture that the house could be built to. With that, what kind, that rendering creates a size expectation that may or may not be the maximum permitted by your zoning. And Ms. Muller testified that the conceptual houses that are shown on the plans were houses that were built.
Yeah, you may well be safe, just come in with that, come in with whatever, just come in with something that they can look at and that kind of matches up to the footprint that Ms. Muller put on her plan.
So what that house looks like in reality.
yeah, it would be very helpful. Even, what honestly would be very helpful for me is not only a rendering of what that house looks like to the degree it's easy enough to do, I'd love to see a picture of one of them built. I think that would certainly help me look at the aesthetics. But I'm not suggesting, you need to go drive to Pennsylvania. I don't want you to, if it's easy enough to do.
Is that the universe of what you're looking for?
Yes.
Ms. Doyle.
Something for the board to consider. Councilman Ring mentioned that he wanted to be able to evaluate whether or not this house would fit into the neighborhood. It may be helpful to go to the tax assessor's office and find out the size of the homes that are on that street. And also, FAR does not relate to garages. So are they one-car garages, or are they two, or are they three? The board might be able to better evaluate the neighborhood if you have that information from the other houses that are on the street.
That's something you would be willing to compile?
Yeah, it'll be right on the tax assessor's card. Yeah, it'll be right on the tax assessor's card. In fact, you could probably just get a photo shot of it and then produce that for the board, just so the board has an idea of scope of the neighborhood, the size of what they're dealing with in that neighborhood.
We can research that.
Thank you, Mr. Bond.
I think that's it.
Yep. Agreed.
How much time does he need, and when do we?
Ms. Doyle, would we be able to take a look at the calendar?
They can do it quickly. we have a very good location on September 19th. We only have Target, and that one is for signage. It's not a very large application.
2 weeks.
Is that too tight for you?
The board will have its chance to deliberate based on what you bring back.
I mean,
If you have it available to submit prior, that, I'm sure that'll be helpful, because we can give it to the board, it just might streamline what you're doing when you're here, but if obviously if you can't. Correct. No, that's correct.
Just give us like 15 sets of whatever you're proposing, and we'll get it to the board members.
Your schedule open the 19th, John?
I don't think so.
I don't, there was no questions for you last time, and I don't anticipate that that would be the case. I mean, I think you're gonna just be limited to this. I'm not expecting that you'll need anything beyond this. Your planner was not available, but I don't want that to delay you.
Yes.
Ms. Doyle, if for some reason they couldn't do the 19th of September, how far out are we looking?
October 3rd.
Okay.
September 19th works for Mr. Bond and the applicant,
Carried without notice.
and we'll carry this meeting without further notice till September 19th. Thank you, Mr. Bond.
Please.
Mm-hmm.
You want me to hold them, Nancy, for Mark?
Okay, moving along this evening, we do have another application that's 20-010, and that's Limited Partnership DBA Verizon Wireless. Extension of approval request, and who will be representing the applicant this evening?
Good evening, Mr. Chairman. Ed Purcell of Price, Smith, Shulman, and D'Arminio for New York SMSA and Limited Partnership, DBA Verizon Wireless is the applicant. New Singular Wireless PCS LLC, that's AT&T, is a co-applicant. I'm going to be speaking for both the applicant and the co-applicant. Gabe Halpern is here representing AT&T, but he's just going to be listening for the most part.
Good evening, Mr. Purcell. Good to have you back. And will he be providing testimony at this time?
Yep, sure. So I'll give just a couple introductory comments. Very nice to be here again. I was here 3 years ago to get the approval for this temp tower, and the purpose of the temporary tower, which is located at Block 168, Lot 18, was to provide a temporary facility for the carrier's antennas to be located while PSE&G replaced its transmission tower on the site, and then we were to move over. The temp tower was to come down. There was a 3-year sunset, which was granted back in 2020. And at the time, if you had asked me, are you going to have to get an extension, I probably would have answered no. But if we did have to get one, I would have thought it would have been something like supply chain issues, something like that. But lo and behold, the thing that brings us back here to get an extension is a migratory bird. And not only a migratory bird, but the law that inhibits our ability to actually do what we need to do was a treaty act signed by Woodrow Wilson in 1918. So, land use law is never boring, always very interesting, always something new. So this has all been very interesting, and but we'll try to keep it brief tonight, and just talk about the birds and what we're asking for. Essentially, we're asking for a 6-month extension. So the approval sunsetted on July 14th. We're asking for an extension until January 14th. But with that, I really only have one witness tonight, Samantha Mertz, who's an assistant project manager and migratory bird specialist with Tri-Leaf. Samantha, do you want to swear her in?
Has Ms. Mertz been sworn on this board before?
No.
No.
Okay.
Raise your right hand. Testify that the, testimony about the truth, the whole truth, and nothing but the truth, so help you God.
Ms. Mertz, can you go over your background and qualifications?
Can you just speak a little closer to the mic or use the handheld if you prefer?
Sure. I have a Bachelor of Science in Environmental Science and Geography from the University of Maryland, Baltimore County. I've worked with Tri-Leaf since 2019, performing migratory bird evaluations, training all of our scientists to perform migratory bird evaluations, reviewing them. I regularly work with the states of Maine down to Virginia on their regulations and coordinating permitting, and anything that we need to do involving the migratory birds nesting on cell towers.
And have you ever been deemed an expert witness in migratory birds before?
By Tri-Leaf.
Okay, but never, have you ever been deemed an expert in front of a board?
No.
Right, and it's a very unique thing, so that makes sense, right? Okay. Having said that, I'd ask that Ms. Mertz be deemed an expert in migratory birds.
Does the board have any objection to Ms. Mertz's qualifications?
No.
Please proceed.
Ms. Mertz, I have a picture here. This is of the subject facility, is that correct? Right here? Yes. And this was taken in May 2023, is that right? Yes. And it shows the...
Do we have that?
I'm going to pass it out.
Okay.
We'll mark this as Exhibit A1. And this shows the osprey nest, is that correct? Correct. Okay.
Thank you.
Thank you.
I'm sorry, what was the date of this?
This was in May of this year, is that correct, Ms. Mertz, these pictures were taken?
Correct.
Okay.
May 2nd.
Okay. Ms. Mertz, can you describe what's in this picture?
This is
A1, yeah.
This is an osprey incubating eggs in a nest. You can see her head just above the rim of the nest.
And this is located on 551 Milltown Road, that's the subject property?
Yes.
Okay. Ms. Mertz, can you just go over the factual background that you're familiar with this matter and what's the story here? May of 2023.
So in early April of 2023, the carrier's permanent installation was being constructed on the adjacent PSE&G transmission tower. When the platform was constructed, it was noticed that there were ospreys and that they had built a nest on the temporary tower. When they left, the contractors left and returned. The ospreys had constructed a nest on the permanent tower. Because of the Migratory Bird Treaty Act and New Jersey state law, that creates a 500-foot buffer, and they were unable to finalize the installation on the PSE&G tower. So we thought that there was going to be permitting involved, but we found out that PSE&G has a running permit with the NJDEP. However, the nest is now inactive, so we'll be able to finalize the permanent installation now that the nest is no longer active.
And the reason that no work could be done and the tower couldn't be taken down and the permanent facility couldn't be made operational is that 500-foot buffer, correct? There's a 500-foot buffer that the Migratory Treaty, Bird Treaty Act requires.
Yes, to protect the migratory birds, the eggs, and the young.
So, I'm sorry, I just want to clarify so I understand. At one point, they were building the nest on the temporary.
Correct.
But then they ultimately built the nest on the new tower.
Correct.
They decided to go to the penthouse suite.
Okay.
Correct.
So,
They
all right.
found a higher platform.